Evidence we just told you about is just so the evidence in the Zimmerman and Martin case, but we wanted to know what today's evidence means for the prosecution and the defense. Well, joining me now is criminal defense attorney Randy Reep. Thank you, Randy, for coming in. Appreciate it. But what we see, the evidence that we have, is that all we have, or will we see more evidence?
The way the discovery process works, that's probably all the evidence that either side has at this time. There's an obligation on the part of both parties to give that evidence and bring it forward. I don't know of other evidence coming forward, but the defense would have whatever the prosecution has at this time.
Okay. Looking at George Zimmerman, the blood on the back of his head, the broken nose, if you will, does that bolster his case one way or the other?
I think it certainly bolsters his case. It gives him a better launching pad than he had, 2 months ago. It does look like he was in a fight, right? He's got the busted nose, he's got the black eyes that accompany it. I'd say that, now we're seeing the color photos of, and it certainly looks like he was involved in a fight, and all the evidence indicates by the witnesses that an altercation.
Okay, well, what about the range where he was shot? It looks like it was a close firing of the gun and an altercation of some kind.
And all that seems relatively consistent with everything we've heard to this point, that there was at least a tussle, and it looks now more like a physical combat between the two, and ultimately a gunshot was fired, and that all makes sense, the range being 6 inches or so with the stippling and the gunpowder. Now,
it's the prosecution's case that George Zimmerman was the aggressor in all of this. Anything that we've seen tonight or heard tonight that would bolster that side of the case?
Well, we've heard all these 911 callers, but they're saying such different things, and that's an important thing. As a defense attorney, I'll tell you that we look for that as often as we can. Is there's evidence, there's absence of evidence, and there's conflicts in the evidence. And we, as a defense attorney, be hanging our hat on that, going, hey, ladies and gentlemen of the jury, there's conflicts here. And the prosecution has the burden of overcoming the presumption of innocence beyond a reasonable doubt. That conflict in the evidence, that is really going towards the defense.
Well, more so than the prosecution. Looking at all of that, which side seems to, I guess, at this point, seems to be in a better position?
When you lay all the information out, I would say that right now the defense is looking a lot better than they did a month ago. But that's always true in a case. When I said to you, I think before, I don't get a case till after the state has put all their evidence together, and then they handed it to the defense, and we start whittling away. And that's when you see it get whittled away, it gets a clearer picture.
Does this go to trial?
I don't think there's enough at this point that a judge would take it out of the hands of a jury. But that's a close call, in my opinion. Even if it gets to a jury, I think the call even gets closer. I think the prosecution is going to have a tough day.
Because the next step, of course, is that the defense are going to claim stand your ground law or self-defense law, and then it will be up to a judge to decide whether or not we will proceed or whether he will throw it out altogether.
That's right. The next step really for the defense is to say, hey, let's say all these facts are true. This isn't even a crime. It's called a C4 motion. All this happened, that's true, but it's not even a crime. And if the judge says, no, it's a question for the question of fact, I think the jury instructions are going to be much better for the defense here.
Okay. Defense Attorney Randy Reep, thank you for coming in. Good to see you.